While Logan Paul and his lawyer have been busy running victory laps and high-fiving themselves for dismissing the CryptoZoo class action case against Paul, the CryptoZoo investors have been silently working on their amended complaint. And on November 14th, the plaintiffs in that case officially filed their second amended complaint, realleging the 26 causes of actions that were dismissed without prejudice. This version of the complaint about doubles the length of the first amended complaint, and it includes way more factual detail in their allegations. And personally, I think that this second amended complaint is so much stronger than the first amended complaint, at least from what I've read of it so far. And like I predicted in my last video before this amended complaint was filed, we can thank Logan Paul's motion to dismiss for that. Let's get into it. So if you're new to this whole CryptoZoo lawsuit saga, I have a whole playlist of videos linked in the description below. So far, I've mostly talked about the Logan Paul / Coffeezilla defamation lawsuit that's related to the class action case, but I've also recently been talking about updates on the class action case as well. And most recently, I talked about how the media and Logan Paul's lawyer, who they exclusively quoted, more or less lied to the public about what was going on with this lawsuit. I won't rehash everything that I said in my last video because you can just go and watch it for yourself. But I will point out that one of the things I did say was that sometimes when you're a defendant and you see all kinds of defects in a plaintiff's complaint, it can be very tempting to want to get that complaint dismissed early on. But the thing is, unless it's an absolutely futile situation, judges are usually going to let the plaintiff amend their complaint, and often multiple times. And that means typically the plaintiff is going to have another shot at fixing all those defects that you pointed out in your motion to dismiss. And at the end of the day, that means strengthening the plaintiff's claims against the defendant. That's because the tighter that complaint is pled, the easier it will be to survive a motion for summary judgment and ultimately to prove those allegations at trial, assuming, of course, the evidence is there to back it up. Or alternatively, if it doesn't end up going to trial, the easier it is for the plaintiffs to convince a mediator to see the case from their perspective and to put greater pressure on the defense for a more advantageous settlement. So sometimes it can actually be more advantageous to the defense to save the fight for another day and allow the plaintiff's case to hobble along in a much weaker state. And so looking at this case, the court dismissed the case against Logan Paul, yes. But of the 27 causes of action, one of those was dismissed with prejudice, meaning it can't be brought again, and the other 26 were dismissed without prejudice, which means the plaintiffs can come back and amend their claims. And in the magistrate judge's report and recommendation, the magistrate judge outlined all of the problems almost like a checklist that needed to be resolved in order for this case to continue forward. And so the plaintiffs took that checklist, and by all appearances, they've gone through to cross their T's and dot their I's. I mean, for starters, like I mentioned before, you can see the difference in just the sheer page numbers. The first amended complaint, the one that got dismissed, was around 115 pages. But the second amended complaint, the one that was just recently filed, is 210. That's because they really took their time this time around to really lay out the facts for all of these claims. So considering all of that, to keep things digestible, let's just focus on the fraud claim in this video. But first, I have to thank this video sponsor. You know, there are thousands of companies out there that are actively collecting your data and trading it for value without your knowledge and consent. And the buyers apparently aren't just other companies. There are some states in the US that are ostensibly buying this information to aid in law enforcement efforts. This is information like your full name, email, home address, phone number, social security number, and more. And so the more you do online, the more likely it is that your data will be bought and sold again and again. And that's why I'm happy to tell you about today's sponsor, Incogni. Incogni is a service that helps to fight back against these persistent data brokers by scanning the internet and getting your data removed for you. And if you go to incogni.com/legalbytes and use the code legalbytes, you'll get 60% off. Have you ever gotten these weird text messages from strange numbers claiming to be something like USPS? And they'll be like talking about how you need to click on some link that they give you so that they can complete delivery of some package or something similar to that. Those are massive red flags for potential scam attempts. And this is just one more reason that it's a good idea to have a service that can remove your information, like your phone number, from the internet so other people can't get it. Now, since signing up, Incogni has gotten my data removed 974 times. And by working with them as opposed to doing it myself, they have saved me over 730 hours at this point. That is an insane amount of time to focus on all the other stuff that keeps me busy these days. And now Incogni's custom removals feature in the unlimited plan and the family unlimited plan means you can pinpoint places on the internet for Incogni to remove your data if you happen to come across it yourself. So if you want some help in the persistent battle of exposure of your personal personal information on the internet, go to incogni.com/legalbytes and use the code Legalbytes to get an exclusive 60% off. The link is in the description below, and be sure to remember to use the code Legalbytes for your 60% off. And thanks again to Incogni for sponsoring this video. Okay, back to the video, and let's focus on the changes that were made to the fraud claim. I really want to do that because that seems to be the cause of action that everyone really is most concerned with anyway. And it also has a lot of overlap with the Logan Paul / Coffeezilla defamation case. Because remember, in that case, Logan Paul has alleged that Coffeezilla defamed him when he said that Paul scammed the investors of CryptoZoo out of their money. So whether or not fraud happened is a very central question to both of these cases. If a court or a jury finds in the class action case that Paul did in fact defraud these investors, it's also game over for Logan Paul in the Coffeezilla case. That's because Coffeezilla would likely be able to use that legal conclusion and apply it in his own case, assuming of course the class action case gets decided before the defamation case does. And if you've been following along on this whole saga on the channel, you probably remember that truth is a complete defense in defamation cases. So let's talk about the problems that the court had with the previous class action complaint's fraud claim. And then we'll talk about the changes that the plaintiffs made in the second amended complaint. Okay, so there were really two big reasons that the magistrate judge dismissed the class action fraud claim against Logan Paul. Those were the elements of materiality and reliance. Specifically, the court said that the plaintiffs needed to plead more specifically to show that the statements / misrepresentations Logan Paul made to the public about CryptoZoo were material. And the court also said that the plaintiffs needed to plead more to specifically show that the plaintiffs had all relied on Paul's statements / misrepresentations to their detriment. So let's first talk about materiality. Materiality means it's the kind of statement that would likely affect the conduct of a reasonable person in a transaction like this. When we're talking about statements advertising a product to the public, courts will want to find the difference between a statement that is a material misrepresentation and one that is quote unquote mere puffery. You see, some countries have very strict laws on advertising, but in the United States, marketers are allowed to quote unquote puff up or exaggerate their product in advertising to a certain point. Specifically, the court said non-actionable puffery comes in at least two possible forms. One, an exaggerated, blustering, and boasting statement upon which no reasonable buyer would be justified in relying. Or two, a general claim of superiority over comparable products that is so vague that it can be understood as nothing more than a mere expression of opinion. However, this doesn't mean that a marketer can just straight up lie about an important feature of the product and present that to the public as a matter of fact. Meaning, they can't say that the product has some kind of cool feature that it doesn't, and they also can't say that it lacks some kind of an important flaw. Now, in the first amended complaint, the plaintiffs basically alleged that Logan Paul called CryptoZoo a fun game that makes you money, and that it was backed by like $1 million with this huge team. But the court said that's really not enough. Just those two statements alone, that sounds like actionable puffery, the court said. Just exaggerations of a concept of a product maybe that was meant to be sold to the public. But the court said there is something here that plaintiffs can potentially hang their hat on if they can be a little bit less vague about it. And that was Logan Paul's statements lying about CryptoZoo's completion date. That's because, according to the court, this seems like an important detail that a reasonable person would care about before deciding to invest in a project like this. But the problem was the court said that plaintiffs weren't totally clear on who said what on which date, and so the court wanted to see more specifics pled to see if these statements were truly material here. Now, in my last video, I said that I actually could see how those statements about CryptoZoo being a fun game that makes you money really actually could be material misrepresentations. That's because if you're saying that it's a fun game, you sound like you're saying that you've played it. If you've played it, that means that the game exists in a state where you can at least play a portion of it, and it's somewhat functional at least. And so in my last video, I said that the plaintiffs could potentially convince the court that these statements are actually material misrepresentations as opposed to mere puffery, but that they probably needed to take some time to explain that in the complaint. And looking at the second amended complaint, that's exactly what they did. First, the plaintiffs cleaned up the details about these various statements, all of which they label Logan Paul's intentionally deceptive statement. They also are very clear to label all of these statements as having been made on August 18th, 2021, and that'll be important in a minute. Now let's look at these individual statements that show up in the second amended complaint. First, they expand on Paul's statement about the game being a fun game that can make you money. Specifically, they said that on August 18th, 2021, Logan Paul said this.
It's so fun. It provides a yield with a token, can earn you money. And
they explained that this was a material misrepresentation because it falsely represented that the CryptoZoo NFTs had a built-in mechanism to generate income or yield for purchasers. But in reality, they say the verified smart contract code on the blockchain contained no such functionality. Second, they alleged that on, once again, August 18th, 2021, Logan Paul also said this.
We have a massive team behind it and are probably out of pocket like $1 million just because we believe it's going to work.
On development.
And here the plaintiffs explain that this is a material misrepresentation because Logan Paul falsely represented that CryptoZoo was backed by a massive team and that he was out of pocket like $1 million, creating the illusion that the project was heavily funded and professionally staffed. But in reality, they say, the project had no such large development team, no meaningful infrastructure, and Paul had only spent around $200,000 of his own money, a fraction of what he claimed publicly. This misrepresentation was material, they say, because investors reasonably understood it to mean that CryptoZoo was a serious, well-capitalized venture with substantial resources to its success. And then they say something that I think is very helpful to the plaintiffs because it adds more context that might otherwise be lost on the judge. In the NFT world, they say, funding and team size directly influence perceptions of credibility, security, and long-term viability. By exaggerating his financial commitment and the scope of his team, Paul induced consumers to believe CryptoZoo was legit when it wasn't. Now, the court might still say that this is still mere puffery because, Paul is just exaggerating how much he went into it. He didn't exactly misrepresent that number. To me, it sounds like a misrepresentation, but I don't know. The court might have a different interpretation of it. But in my opinion, the plaintiffs at least gave themselves a better chance at convincing the judge otherwise by adding this extra context. Anyway, then we get to Logan Paul's third statement that plaintiffs said was a material misrepresentation and once again made on August 18th, 2021.
It's with the product, bro, and I'm super fucking particular about this product. It's taken 6 months. Half the projects, not half. Well, yeah, half. The ones that I'm invested in right now, I'm looking at like the timelines on it. They're quick, bro. It's quick to make a digital asset with, unique, randomly generated characteristics. We handmade art for the past 6 months, bro. Approval, very specific notes, 10 different artists making art for our project.
And here the plaintiffs talk about how, in reality, the images used in the project were stock images, pre-existing publicly available animal photographs and illustrations that were crudely edited and combined, not original works of art. And then again, they give some extra context as to why this is so important in the NFT world specifically. In the NFT world, claims of handmade or original art are material because much of an NFT's value derives from its uniqueness, authenticity, and the creative labor behind it. By falsely asserting that the images were painstakingly hand-drawn, Paul misled buyers into believing that they were purchasing exclusive, high-effort digital collectibles that generated a yield. And then they go on to show an example of one of those hybrid animals that CryptoZoo was showing off as its art that was supposedly bespoke.
We handmade art.
And then they show how this supposedly maximum effort hybrid image was actually just a merging of two very clearly publicly available stock images. Anyway, then we get to the final statement that was alleged by the plaintiffs in the second amended complaint. And in my opinion, this one is a real doozy. Here, they said that once again on August 18th, 2021, Logan Paul said the following.
Project. A development team that has to be wizards because you're dealing with blockchain, people's money, transactions. And it's going to be on the Binance Smart Chain. I'm saying this here now because the Ethereum network, the gas fees don't make sense for the type of continuous and frequent transactions taking place in our game. Like it's a really fun game that makes you money. Kids are addicted to it. Our developers' kids, all of them, cannot stop playing the game.
So this apparently was a huge lie. And if you remember, this was the kind of statement that the magistrate judge said would be a material misrepresentation if the plaintiffs could clean up their allegations as to who said it and when. And well, here you have it. I mean, Paul said that developers' kids were addicted to the game, and obviously that can't be true because still to this day, it doesn't exist in any functional form. And that's what the plaintiffs explain here. They say, at the time this statement was made, no game existed. This statement was false when it was made. Paul's own cross claims reveal that on September 8th, 2021, that's almost a month after Logan Paul made the statement to the public, by the way, Paul saw that no functional game existed, no playable build had ever been delivered, and Paul himself privately acknowledged confusion and dissatisfaction with the state of the development. Paul therefore could not have genuinely believed that CryptoZoo was a fun game on August 18th, 2021, because he had never played it. Additionally, he had never seen another play it because the game did not exist in any functional form at the time, and by his own later admission, no playable build had ever been delivered. Boom. Honestly, it couldn't be more clear. He's talking about developers' kids being addicted to a game that simply doesn't exist. This is obviously a lie, and a very specific one at that, and it's easy to see how Paul would have at least been reckless in making that statement when a few weeks later he privately acknowledged that he was disappointed in the game that still wasn't functional. And remember, I've been pointing out along the way that the plaintiffs really highlight here that all of these statements were made on August 18th, 2021. This was on a specific episode of his Impaulsive podcast. And I said earlier that that date was going to be very important, and we would talk about it a little bit more later in the video. That's going to be right now. Because what we're going to talk about now is the fact that the court had an issue in the First Amendment complaint with their allegations of the element of reliance in their fraud claim. Remember how I said earlier in this video that the court said that the plaintiffs needed to plead more specifically to show that the plaintiffs all had relied on Paul's statements/misrepresentations to their detriment. Basically, this means that the plaintiffs have to show that whatever Paul said had to have induced the plaintiffs to either act or refrain from acting to their detriment. But in the report and recommendation, the court said that in the First Amendment complaint, the plaintiff's allegations about this element were just too vague. Now, the court pointed out that it seemed like Logan Paul allegedly made the statements at issue on August 18th, 2021. And the court said the vast majority of the plaintiffs purchased CryptoZoo products on or after that date. Now, that is a good thing for the plaintiffs, at least to start with, because it means that the timeline of the plaintiffs being impacted by Paul's misrepresentations makes sense if they bought into the project after he made those statements. But the court said that the plaintiffs needed more. Here, the court continues saying, so presumably most could have heard the defendant Paul's statement, believed in the availability of a finished product, and purchased accordingly. But plaintiffs only allege defendants misrepresented the status of the CryptoZoo game to entice Paul's loyal online fans and the public into investing into CryptoZoo products, and then failed to ever provide a functional CryptoZoo game to use said CryptoZoo products. Based on plaintiffs' vague assertion alone, it is not clear which plaintiffs, if any, heard defendant Paul's initial promotion statement, let alone acted in reliance on it. And so basically the plaintiffs needed to allege that they had heard these statements and somehow been impacted by them so as to buy into the project. And here the plaintiffs allege throughout the Second Amendment complaint that the plaintiffs reasonably relied on Logan Paul's specific statements in making their purchases. Now, I'm not sure if the court will come back and say you actually need to allege something more specific than that for reliance, but this at least is a big improvement over the First Amendment complaint, because in that version, the only places where I think that kind of language appeared was in other state-specific causes of action, not the fraud claim. And I do think that the sufficiency of allegation issue around this element is helped by just how specifically the plaintiffs allege the facts and context around the statements themselves. They're very clear that Logan Paul made all of these statements himself on August 18th, 2021 during his Impaulsive podcast. And they really extend out what he actually said in these various statements. So in my opinion, I really do think that this element has also been strengthened quite a bit as well. So now looking back at this, I think the plaintiffs really took this opportunity to lay out a much stronger foundation for this and other claims. And I really think that the Second Amendment complaint is a much stronger version of the complaint. So this means, assuming of course this complaint survives another motion to dismiss, assuming Logan Paul decides to file another one, these claims should be quite a bit easier to prove at trial if it gets that far. And the thing is, this wouldn't have happened if Logan Paul hadn't moved to dismiss the complaint. So really, while he was high-fiving himself for officially getting the whole lawsuit dismissed against him, as it turns out, he was actually just ushering in a much stronger complaint. And this could end up really biting him in the ass. But those are my thoughts. What do you think? Do you think these claims are stronger now that the plaintiffs have filed their Second Amendment complaint? Or do you think that Logan Paul is just going to end up getting this version dismissed as well? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed it or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. pod. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.